Pam Bondi spent 20 years making sure this moment would never happen. She survived the Trump University donation scandal. She survived Senate confirmation hearings that dissected every decision she ever made as Florida's Attorney General. She built a reputation precise enough, polished enough, and legally clean enough to survive in rooms where one mistake ends careers. Right now, that reputation is gone, because a formal disbarment complaint has been filed with the Florida bar. Not a suspension request, not a reprimand, disbarment. The permanent, irreversible end of her right to practice law. And the reason she is sitting in the middle of this crisis comes down to one thing: a documented pattern of conduct that the people who filed this complaint say cannot be explained away as aggressive lawyering. It is too specific. It is too consistent, and the paper trail behind it is too deep. So what happens when the woman who built her entire identity on being the law and order professional in the room suddenly finds herself on the wrong side of the bar's most serious sanction? One filing, one record, one question that the Florida bar now has to answer. And I'm going to show you exactly why legal observers are calling this the most consequential bar proceeding against a sitting cabinet official in modern American history. Here is what most people don't understand about disbarment. It is not a common outcome. Bar associations have a full spectrum of sanctions available to them: reprimands, probation, temporary suspension, conditions on practice. Disbarment sits at the absolute end of that spectrum. It requires a formal finding that the attorney's conduct was so fundamentally contrary to the professional standards every licensed lawyer swears to uphold that the bar has determined they cannot be trusted to practice law ever again. Not next year, not after a rehabilitation period, ever. The fact that this word is attached to Bondi's name right now tells you something critical about what is being alleged. This is not a technicality. This is not a paperwork error or a billing dispute. The people who filed this complaint are arguing that her conduct crossed a line so fundamental that the only appropriate professional response is permanent removal. And the Florida bar does not open formal proceedings on complaints that haven't cleared an initial threshold review. Something in this filing was specific enough, documented enough, and serious enough to move past the initial screening. That alone changes what this is. Let's go back to where the foundation of this complaint was actually built, because nothing about this situation arrived without history. In 2013, when Bondi was Florida's Attorney General, her office declined to join a multi-state fraud investigation into Trump University. The timing mattered. Shortly before that decision, a Trump-affiliated PAC donated to her political committee. The connection was investigated at the time, the explanation was accepted, but the documentation of that sequence entered the permanent record and never left it. That is the thing about documented sequences in the legal world. They don't expire, they don't soften with time. Every subsequent action taken by the person at the center of that record gets measured against it. The complaint now before the Florida bar is not built on that 2013 decision alone. It is built on what came after, a pattern of conduct across multiple professional contexts that the filers argue reflects the same underlying problem: the willingness to use the authority of a law license to advance positions that conflict with prior professional obligations and documented facts. Patterns are what bar proceedings are designed to find, and a pattern, once documented across multiple incidents and multiple years, is far more dangerous to a law license than any single isolated decision. Here is where the complaint becomes specific, and specificity is what decides bar proceedings. The filing centers on public statements Bondi made in her professional capacity. Statements that the filers allege were not simply aggressive advocacy or partisan framing. Statements they allege were knowingly inconsistent with the documented record she had direct access to. That distinction matters enormously in bar ethics. An attorney who makes a mistake in a public statement is in a difficult position. An attorney who makes a statement knowing it contradicts documented facts she is professionally aware of is in a categorically different position. One is error, the other is the kind of conduct that the rules of professional conduct are specifically designed to address. The filing maps specific statements against specific documentary contradictions. It builds a case that the gap between what she said and what the record shows was not accidental, it was deliberate. And if the Florida bar finds that argument credible, the disbarment case does not need much more than that. Then came the hearing, and this is the moment legal observers keep coming back to. During a congressional oversight session, Bondi was asked a direct question about a prior legal representation, a specific client, a specific position she had taken in her professional legal capacity that appeared to directly contradict the public position she was now advancing. The question was not complicated. It was a factual yes or no question about something already in the documented record. She didn't answer it. Not with a denial, not with a legal explanation. She redirected, immediately, smoothly, with the practiced ease of someone who had clearly anticipated the question and decided in advance not to answer it directly. The questioner asked again, she redirected again. This happened 3 times before the exchange moved on. Every attorney watching that sequence understood what they were seeing. That is not confusion. That is not a failure to recall. That is a deliberate decision not to answer a specific question about a specific fact because a direct answer creates legal exposure. And in a bar proceeding, what an attorney refuses to say under pressure is examined just as carefully as what they do say. The refusal is now in the record. And the document that prompted the question is also in the record. And the bar gets to compare them. Here is what her legal team will argue. It is important to take this seriously because the argument has real substance. Bondi has operated at the highest levels of American law and politics for over 2 decades. She has survived intense professional scrutiny before. The Florida bar operates through a rigorous procedural framework that makes it genuinely difficult to move from complaint to formal charges, to actual disbarment. The burden of proof is high. The procedural protections are significant. The political context of this complaint, filed during a period of extraordinary partisan conflict over her current role in the administration, is something the bar will weigh carefully. Her legal team will argue that the statements described in the complaint fall within the range of permissible professional advocacy. They will argue that the filers have stripped context from communications in order to manufacture a contradiction that does not actually exist. They will argue political motivation at every stage, and some of those arguments will carry weight. But here is what her defenders cannot answer. The documents don't change based on who filed the complaint. A prior representation either exists in the record or it doesn't. A statement is either consistent with what she knew at the time or it isn't. The documentary contradictions identified in the filing either hold up under scrutiny or they don't. That is the trap, and it is the exact same trap that has caught other high-profile figures in bar proceedings before. People who believed their public stature, their political connections, their track record of survival would insulate them from the granular document-by-document analysis that bar proceedings are built on. Political defense is a strategy. Documentary record is a fact. When those two things collide in a formal proceeding, the documents win more often than the strategy does. Her attorneys know this, which is why every word of her formal response will be constructed with extraordinary precision against the specific documents the filers are relying on. Because one wrong sentence in a bar defense becomes ammunition for the next phase. The personal cost here is something the political coverage keeps missing. Pam Bondi's entire professional identity is built on one thing above everything else: the law license, not the television appearances, not the political appointments, the license. It is what gives her standing as a legal professional in every room she walks into. It is the credential that separates her from a political commentator. And disbarment doesn't suspend that credential temporarily. It removes it permanently. No political ally reverses it. No administration change fixes it. The Florida bar's disciplinary process is institutionally independent of every political current surrounding the people it reviews. And that independence is exactly what makes this different from every other professional challenge she has faced. She cannot fight this the way she fights everything else. She cannot reframe it on television. She cannot wait for the political winds to shift. She has to answer the documents, and the documents are waiting. Here is where things stand right now. The complaint is filed. The formal review is underway. Her legal team is building a response. The proceeding will move forward on its own timeline regardless of what happens in the political world outside it. She is not facing criminal charges. But she is facing the one professional sanction that cannot be undone by anyone with political power. Bondi has survived serious scrutiny before. She has navigated challenges that ended other careers. But this is a different kind of fight. Because this proceeding will be decided by lawyers reviewing documents and applying a single standard. Does the conduct described meet the threshold for disbarment? Watch the next 60 days. The bar's response to the formal filing will tell you more about the direction of this case than anything said publicly by her allies or her critics. Because somewhere inside that complaint, there is either the documentation that resolves this quietly or the documentation that takes this to a formal hearing. The attorneys reviewing it already know which one they are reading. The filing has landed, the record is open. And for the first time in a very long time, Pam Bondi's professional future is not in her own hands. There is something that nobody in the political coverage wants to sit with. And it is the most important thing about this entire situation. Pam Bondi is not a peripheral figure in American legal and political life. She is a former state attorney general. She is a sitting cabinet official. She is a licensed attorney who has used that license as a professional credential in the most consequential rooms in American government. When someone at that level faces a formal disbarment proceeding, it is not just a personal professional crisis. It is a question about how the institutions that govern the legal profession respond when one of their own operates at the intersection of law and political power in ways that test the outer limits of professional ethics. The Florida bar has to answer that question now, not in the abstract, with a specific complaint, specific documents, and a specific record in front of them. How they answer it will matter far beyond this case. Because the lawyers watching this proceeding are not just watching to see what happens to Bondi. They are watching to see where the line actually is, where the bar draws the boundary between aggressive professional advocacy and conduct that warrants the most serious sanction available. That line has never been drawn at this level of public visibility before. And when it is drawn, everyone in the legal profession will know exactly where it sits. The complaint is real, the proceeding is real, and whatever comes next, that line is about to be drawn in permanent ink.